Good afternoon again, everybody. I'm Tammy Welty. I'm the Director of Training and Communications here at Bradford Barthel, and we are so glad you could join us for today's subrogation webinar with Peter Fitzpatrick and Scott Starr. Peter Fitzpatrick is a partner and our subrogation expert. We have been lucky enough to have Peter on our team since 2005, and since I have a child who was born in 2005, I can easily tell you that was 20 whole years ago. So congratulations on 20 years, Peter. That's amazing.
Thank you, Tammy.
I have no doubt that all of you are going to learn a ton from him today. So let's have Scott go ahead and start by introducing himself.
Hey everyone, I'm Scott Starr. For those of you that don't know me, I've actually got Peter beat by a few years, having started here in 2002. I've actually done quite a bit with subrogation in the past, so I'll be monitoring the questions today, and I'll try to answer them. If they seem like good topics, we'll try to get to them as well with Peter so we can discuss them as a group. Hope you guys enjoy everything today. Should be a really good presentation.
Okay, thank you. And as Tammy said, I have been at Bradford Barthel for 20 years as of August 29, 2025. Loving it for all that time. It's been great, a great atmosphere, great work environment, and it's been subrogation cases for that period of time. I handle some other employment cases and 132As, serious and willful, some other petitions that you know about in your work comp cases, but primarily subrogation. So we're going to go through this pretty briskly because we have an hour, but don't worry, you can get a copy of this. We can send you this PowerPoint, and then you can look at it and ask Scott questions later or ask me questions later because there's quite a bit of information in there. So don't worry about it, but we do have to move fairly quickly. So let me do that. Okay, let's get to it here. Okay, what is subrogation? What is it? I always tell people count to three. 1, 2, 3. If you're just 1 and 2, that means that's the employee and the employer. Then you're just in work comp. You just have an industrial injury in work comp with 1 and 2. Those are the only players. But if you have a number 3, that's what you're looking for. Number 3. And that's why it's called third-party civil litigation. That's where subrogation comes in. Some third party caused the injury, caused the industrial injury. So you need that third party to proceed in civil court. Otherwise, again, if you're just 1 and 2, that's just a work comp claim. You just have employee, employer. Okay, some of the examples are the auto cases are really the most the make up the most of subrogation are auto v auto, because that's some third party driver that got into an accident with the employee and caused an industrial injury. So we're going to go after that third party driver, or I will, in a subrogation case. Slip and falls as well. You're slipping on something caused by a third party, a sidewalk that's not part of the employer's building, some other entity. Always number 3, looking for number 3. Construction, there's always number 3s in construction because there's subcontractors, other people that'll cause an injury to the worker that's an industrial injury. And then we'll go after that party, a subcontractor or some other worker that injured our industrial worker. Okay, the last one there, secretary and has an injury with a defective chair. That's products liability. We'll get into that too. That's a third party. That's someone who built that chair. It's defective. We go after that person. And these are, again, subrogation potential, always looking for that other party. Assaults by somebody else, another party. Injuries away from the employer's premises. We just talked about that. Injuries caused by equipment. Again, that's some manufacturer that's a third party. Okay. And these, this next slide, aggravations. You can have aggravations as well of an industrial injury. And these can be before and after an industrial injury, but from my experience, it happens more after the industrial injury. So someone has an injury at work, a back injury of some kind at work, and then they have an auto accident Subsequently, well, that could aggravate that industrial injury. It's always good if the benefit printout kind of spikes after after the auto accident. You get a spike in treatment. Then you can show that that auto accident that happened after um, caused further benefits to be paid by the carrier. So then we can go after that. We can go after that party, auto policy and go from there. But again, you have to show that event, subsequent event, uh, required the carrier to pay more in benefits. Okay. Um, and again, here, as we always say, you can always pick up the phone, call us, call Scott, call myself. We can talk about whether there's subrogation potential for your case. Always happy to help you, whether it's people in my firm, my colleagues, other attorneys or adjusters. We can determine if there's subrogation. Okay. Notice. So what do you have to do to put someone on notice? Well, the worker, the applicant slash plaintiff, this is a labor code section 3853. That applicant slash plaintiff is required to give us, the carrier, the workers' compensation insurance carrier, notice that he filed a claim. Do we get that all the time? No, we don't. We find it ourselves. In my practice, my secretary, Angela Fowler, we search the civil filings at times to find these third-party cases. But technically, they're supposed to give us notice that they filed a complaint, so now we know there's a third-party complaint out there. But again, it's not always done. And this is, the employee, it can be a letter or somewhere they're telling you, it doesn't have to be on a pleading that I am an individual worker who has filed a third-party civil case, and then we're going to join it somehow. We're going to talk about that. How do we join it? Well, there's multiple ways to do that. Okay, but often you'll see, and my colleagues come to me and they have subpoenas that have civil case numbers on there. So then we know, well, obviously, there's a third-party case. It's a civil case number. That's easy to track that one down, and then we can join that civil case. Deposition testimony can be taken in a civil case, and then we know that's happening. So we're always looking around if we feel that there's a third-party case out there. So then we do our own due diligence as well. Okay. Okay, there's some limitations on subrogation, guys. One of them is medical malpractice. So if the individual worker files a medical malpractice case against some healthcare professional, we, as the carrier, we cannot join that. That's a statutory bar. It's a statute that says you, work comp carrier, cannot subrogate against medical malpractice cases. That's just one of the limitations. The legislature decided that was a good idea. They did that. Okay. But there's a few exceptions. If it's not straight medical malpractice, you could have some sort of injury that's not due to, surgery or some physician's lack of care. And again, these fall into products liability cases mainly, but some negligence type battery cases is possible. That would be just a straight negligence case because it didn't have to do with a surgical procedure and medical devices. That's strict products liability. That's a third party case. You could do that. Okay. Now here it gets these cases get a little difficult sometimes with this general special employment where you'll have an employment agency and you'll have the employer who got an employee from the employment agency, and then there's contracts that go between those two parties, between the staffing agency and the employer. And sometimes there's subrogation waivers in there that says or that indicate you as the employer, you as the carrier, and the carrier, by the way, when I say, the carrier is carrier slash, insurer slash uninsured. So carrier slash employer, you cannot, subrogate against a certain party due to the contract language. So you always need the contract in those general special situations. Does it prevent us from directly going against that third party? Sometimes it does. So that's something we have to look at. So I always ask the carrier, please send me the contract between the staffing agency and the employer so I can see if we can proceed. And then there's uninsured, underinsured. There's no subrogation potential there because there's no third party there. That uninsured, underinsured is the worker's own insurance. So he's number one, right? Or she, one and two. There's not three there. So we can't go after the worker's own insurance policy. That's just another limitation. Okay. And now we'll move on to statute of limitations. Okay, government entities. This is where you got to be careful because government entities have a shorter statute of limitations, only 6 months. So if it's, the county of Riverside, and I have one of those cases pending, we had to file the complaint within 6 months. It's actually an administrative complaint. So we have to file that administrative complaint within 6 months, and then they have to act on it. And they can reject it. In this example, if the city of Riverside rejects it, which they did in our case, then we have 6 months from that rejection to file a civil action, which we did. And now that case is pending, but that's a shorter time frame. We'll get to the other time frame in a minute. Now, if you get no response from that government entity, the city of Riverside, I'm using that example, they don't respond at all. You file with them and nothing. Okay, that's good in some ways because then the 2-year statute applies. The general negligence statute of 2 years applies. So in some ways, you probably don't want them to respond. Then you have more time. Okay. Okay. SIGA claims this is an insolvent carrier taken over by SIGA. The carrier goes into bankruptcy, is insolvent. So then you can't subrogate against that bankruptcy entity, basically. You can't subrogate against SIGA, who took over for the insolvent carrier. That doesn't happen too often, but it has happened. Okay, but here we go. So statute of limitations for straight subrogation, personal injury cases, 2 years. So 2 years from the date of the injury. Yeah, as it notes here, take it seriously. Unlike work comp, statute of limitations are strictly enforced. Absolutely. And you have to get there ahead of time. So we always try to file a couple of weeks prior to the statute running so we don't have any issues with that. But yeah, two years for your auto v auto, slip and fall, products liability. And then, okay, tolling is when one of the parties, one or two, well, actually, in this case, number one, the employee, right? Number one has filed something in civil court, filed a petition, filed a complaint. So that protects us. If we come in late, we don't find out about it until after 2 years, for example, and then we see this case has been pending, we can join it anytime up till trial. So that's good. So someone has to protect it. So, well, the person, the industrial worker, or the carrier, or the work comp carrier. Either of those two parties must file within 2 years, and then the other party can join, whichever that party is, can join that case after 2 years even. Anytime up until the time of trial. Okay. But again, as I said, it's only satisfied if the employee or the carrier files in a letter to the third-party insurance company. That will not toll the statute. You actually have to file the complaint. You got to file the complaint at the proper courthouse. Okay, here's the government code section that I mentioned earlier. That's the 6 months. So that's, if you know it's a county of Riverside, county of Los Angeles, that's a government entity. You must act quickly if you believe they're responsible. that third party is responsible for the injury. So you have to do that. There's some late filing. You can file after 6 months. If you can show good cause, but you don't want to get into that. That's a law in motion practice that you could lose. Okay, and again, once it's filed, 6 months, they reject it. You have another 6 months to file the civil complaint. You can't go to court first against a government entity. You must exhaust administrative remedies. That's why they have this short period of time. Again, if it's more than 45 days, you get the 2 years. Okay. Yeah, and you're always, you want to be careful about what government entity it is. So you have to follow up, have yourself, your staff follow up, and these government entities, they have forms that you can Google and get them pretty easily. A claim form for the city of Riverside. Best to use that form, and then you put all the information in there. Okay. Yeah, here, this situation, this slide is if you don't, as the carrier, file in time, but the employee did, you could file a complaint, an intervention against the city of Riverside, even though you didn't do it within 6 months. So you could do that as long as the individual worker has done that, that is okay to do. All right. Again, subrogation, or always, I should say, not again, but always early investigation. That's really important. The sooner we get the case as lawyers, as the subrogation attorney, we can start our investigation ourselves. We may need to hire an investigator. The carriers sometimes do that as well. They send out investigators on certain cases. That's very helpful. And then the carrier sends us a subrogation investigation report. That's really great because that has all the information in there, generally, witnesses, and then we can decide, is this really subrogation or not? So that's what you want to do. You want to start early. That 2 years can go pretty quickly. Okay. Witness statements, those are always important. You need them for whatever case. Construction accidents, as it's saying here, you want to get them as soon as possible. That's where that investigator, perhaps for the carrier, for the work comp carrier, can get that for you and get statements on what happened. Who did this? Who was at fault? Was the worker at fault? That's another issue that we'll get to. So we need to obviously get all the statements that we can as contemporaneous with the event as possible. You want it fresh in their minds so that you have an accurate statement. Okay, traffic collision reports. These are the most popular. They happen a lot. Auto accidents, obviously, in California. So we got a lot of auto v. auto subrogation cases. Again, that's that third-party driver. We go after that person and their policy limits, whatever they are. So we want, number one, the traffic collision report. We want photographs of the cars. Both equally important. Traffic collision report tells you who caused the accident. So it needs to be that third party who caused the accident. If they did, great. Then you can move forward. And photos tell you the severity of the collision. Was it a little fender bender? Is there any? Sometimes we'll get photos and there's no visible damage to the automobiles. That makes the case a little tougher if there's no physical damage. But still, we'll make our determination from all the evidence that we had. But traffic collision report is absolutely the most important document because it lays out the facts of the accident for you and allows you to find that third party. He's listed in the traffic collision report, he or she, and their insurance company. They better have insurance because you don't want to proceed against someone who doesn't have insurance. That's a waste of time for subrogation, in my opinion. Okay, again, what do we want to do? We want to get as much as possible in these auto accidents. And I always ask the adjuster to help me with photographs because sometimes we can contact the employer directly and other times they do not want to be contacted directly. so I can't get information from them. So the carrier, who is the insurer, can contact the insured, the employer, and get this for us. And I need all these things, these photographs, 911 recordings. That would be more maybe in a catastrophic type injury, but they're there. Any information, and depending on the severity, you get the documents for repairs to the vehicles. So that's important to get through from the employer. Okay, liability insurance policies. That is what determines how much is available. The minimum policies used to be 1530s, so 15,000 if just two people involved. Now, thank goodness, since 2025, it went up to 3060. So the minimum is now 36. So 30,000 minimum for a 2025. Before that's only 15,000. So you could have a lien of $1 million. But if the policy is only 15, you're likely only to get 15. I mean, can you go after the person individually against their assets? Yes, but that's a waste of time, especially if someone has a 15 policy. They're unlikely to be able to pay $1 million judgment. That's just a waste of paper. So you're only getting the 15, but now you get 3060. So that's good. Yeah, and this one, again, motor vehicles, which are, the most often, the most often litigated subrogation cases are these auto cases, and catastrophic ones again have high values, but you need the policy limits also to be at least 100, 300, or if it's a truck accident, that's best, because those truck big rigs usually have $1 million policies and even excess policies on top of that, so that can pay off a big subrogation lien. The subrogation lien is the medical and the indemnity and the C&R payments, the stip and award payments. Those are all your subrogation damages. That's what the carrier paid out. That's what they want back in subrogation. They want to be reimbursed for medical, indemnity, C&R, stip. That's basically all you're getting back. The other stuff that's administrative costs, you don't get that back. That's a cost of doing business, basically. Okay, product defect. Again, this is this third party product defect. You're trying to determine what happened to that particular machine or product that caused the injury to the worker. So the best way is to, if you can, is to keep that that product, that machine, in the same condition that it was at the time of the accident. That's not always possible. Here it's saying, in this slide, take possession, place, and storage. I mean, yes, but some of these employers, they can't do that. That machine's part of their business. So then you got to send an expert over there who has to recreate what happened, but that's generally what happens, because these employers can't simply red tag something and not use it again. But products cases always require expert testimony. Products cases can only be proved by a products liability expert. So you got to hire one of those right away. That's the only way. The other side will have theirs. They'll defend with theirs. We take ours in there. We have him go take a look at it, and then it's a battle of the experts. Is it a defective machine? We say yes. They say no. You litigate it. Okay. Okay. Yeah. Now here, this is just, the employer may have some relationship with the manufacturer, good or bad, and there's issues there. Maybe the manufacturer takes the product back. Well, that's where the experts come in. They're good at untangling these things and figuring out what exactly happened, what the manufacturer did subsequently to the machine to perhaps, remedy a defect. But again, that's all expert testimony. You don't have to do it yourself as the adjuster. I don't do it myself as a lawyer. We're not experts. We don't know what caused the failure of a machine. That's why we hire them. Okay, and then you do want to photograph it, as I said, red tag it if you can, and take it out of commission, and keep it where your expert can see it in a pristine, so to speak, condition. No changes to it. So that's something, again, for the expert to do. You don't have to worry about that. And then you also want from the employer purchase orders, invoices, manuals, maintenance records. Maintenance records, very important. Did the employer maintain it, or did the third party maintain it and it still failed? Well, that's where you go through all your documents. And again, photographs are great. Surveillance cameras better. If there's surveillance video of what happened, then you can definitely make a decision about what happened. You'll see that a person, even like in a slip and fall case, you want a video. And this is arguing again, if the defendant destroys videos, well, or destroys some evidence, that's a whole nother spoliation of evidence, as it's called in civil, where you can bring motions for sanctions against the party who's doing something like that. That doesn't happen too often, but it can happen. Okay, all right, premises liability, guys. Moving on, we got premises liability, and this is slip and fall type cases. And there, you've got the owner of the building, you got the lessee, who's generally who can be the employer, right? The employer is leasing the building from the owner. That's where as I mentioned earlier, that's where you need the contracts between the lessee, who could be the employer, against the owner. There may be subrogation waivers or indemnity clauses, and you can't sue the owner. So then what do? Well, you can't bring a direct action against them, but you could file a notice of lien if the individual worker brings some action against the owner, because the individual worker didn't sign any lease. They didn't sign a contract. So they can sue the owner, and then you file notice of lien. There's negative aspects of that. We'll get to that. Okay. Filing just a notice of lien. Okay, construction accidents. Again, you got a lot of third parties, guys, on construction accidents. Subcontractors, the employees of subcontractors, independent contractors. So that takes a little bit more work to get all this information. Photographs, again, I keep getting back to this, but this is where it really comes in. Insurance certificates, contracts between the parties that potentially can block you from subrogation. And I can help you with those issues if you run into one of those cases. But mainly get the contract between the parties. I see Scott there.
Yeah, we had a question, Peter.
Yes.
Someone was asking about OSHA and how that would kind of play into whether you can get the reports and what effect those would have on these types of claims.
Yeah, good question. Thank you, Scott. So, yes, if there's a Cal OSHA report out there, then I get documents from the employer and say, please give me all the documents that you gave to Cal OSHA employer. And they do sometimes, or sometimes they don't. But what we do is subpoena that right away. So that's a big issue, because Cal OSHA can only cite the employer. So they can only create employer negligence for you. Cal OSHA doesn't go against third parties. They don't say, oh, the manufacturer manufactured this incorrectly and they should have used, a different safety guard. No, they don't do that. Cal OSHA can only cite the employer. So if there's Cal OSHA out there, you've got to get it right away. And that's employer negligence, because there'll be something in there. Well, sometimes maybe nothing in there, but many times, the majority of the time, there's going to be some issue of employer negligence, failure to train, failure to provide safety equipment. That's all employer negligence and we're going to talk about this, that will affect the amount of recovery that you have. So, yes. So you have to get that report right away. Cal OSHA, very important, and we subpoena it right away as soon as possible. Okay.
Thanks, Peter.
Thank you, Scott. Yeah, we're going to get to that too. Let's see. Yeah, this is talking about again notification where you want to get in there, you want to file a notice of lien, you want to be a complainant intervention. Can the employee settle around you? Yes, he can settle around you, but generally that third party in that settlement and release agreement, and would need a copy of that too. It says specifically, you, individual worker, are responsible for any and all liens, including the workers' compensation lien. So, as we all remember in law school, right? Our contracts class, we're a third-party beneficiary to that contract because the employee has now agreed through that contract to satisfy the lien. So they can't walk away completely. I mean, they can think they're settling around you, and I've had I've had attorneys try to, but you can go after them in various ways. If they refuse to acknowledge the lien, especially if it's in most of these releases, the language is in there. It's in there. Okay. That they're responsible for it. Okay, but yeah, notice again, you want to get you need notice of some type of settlement from the worker, but then again, we want to contact the third party, and we contact that third party carrier. So that's that defendant, that third party carrier. I send them a letter generally right away and say, I represent X carrier. Here's our lien. Please contact me to discuss settlement of it. So they know that we're out there. And carriers do it too. A lot of the work comp carriers, I get a file from them. They've already sent letters to that third party insurance carrier saying we have subrogation rights and it's Labor Code Section 3852. Labor Code Section 3852 et sec. We have certain rights you need to be aware of. Okay. Well, yeah, if you didn't give notice at all and everything settles, and then what do you do? Well, those are the tougher situations. You didn't join the case. You didn't file a notice of lien. More than 2 years has gone by. The case is over. The money's been distributed. What do you do? Well, those are tough to recover on. If you can still show that the defendant had notice of the claim in some form, you can still argue that you have some reimbursement rights, especially if they haven't paid out the policy limits. Then you can make that argument. But you don't want to put yourself in that situation. You want to file a notice of lien in that case, and you want to put that carrier on notice right away. And here it is, notice of lien. That's what we do. As soon as I get a case, it comes in, whether I'm going to join it as a plaintiff in intervention and file a complaint in intervention, I'm probably going to do that. But before I do it, I file a notice of lien right away, whatever court it is, LA Superior, Riverside, Monterey, Contra Costa County, San Diego. We file them immediately so that court and all the parties know that we're in the case. So you want to do that right away. And that's the first thing that I do with Angela, my assistant. We make sure that gets done. Excuse me. And again, as I'm saying, what does it do? Well, then everyone knows we're in the action. Everyone knows that we're not a party, but and we're going to get to that, but that we have subrogation rights. We have statutory first lien rights. And that's why we do it right away. But now, okay, if you just file a notice of lien, that sounds good on paper, but then you're not a party. So you're not officially a party. So no discovery, you don't get pleadings, they don't tell you when there's a court hearing. I mean, you can follow along, and we do, but you're not part of it. So it makes you're in the dark a bit if it's just a notice of lien. So again, in theory, it allows you to recover without at a low cost, but beware. All these things can happen to you. You're not a party. You're not participating. You don't know everything that's going on. So there can be settlements you don't know about. There can be employer negligence that has come up in depositions that you don't know about. So it puts you at a disadvantage. You'd rather protect the carrier by joining the lawsuit. That's what I say. If it's worth it, and it's not a $6,000 lien, for example, where you can't really join a case at $6,000, that wouldn't even cover the attorney's fees, right? So you can't do that. So you need to join it. You need to become a plaintiff in intervention. If it's worth it, you should do it. And the cost, really, these days, with everything being remote since 2020, basically since COVID, and almost everything except going to trial in a civil court is remote, the cost is about the same. It it helps you to join. So that's what you want to do. And again, the disadvantages of just filing a notice of lien, you're left exposed to all these negligence claims, and you don't know if they're legitimate or not. And of course, the parties are going to say, the plaintiff's going to say, the applicant's attorney's going to say, employer negligence, employer negligence. You don't get any recovery because of employer negligence. Well, you want to fight that. Okay. And here again, these are all the disadvantages of just filing a lien, which used to be a good idea maybe 10 years ago, but or more than 5 years ago. But again, now it's just best to join. If you have a legitimate claim and the lien is substantial enough, you can fight all these defenses. You can be at the deposition. You can ask questions. You can set your own depositions. You can protect the employer. That's what you want to do. Okay, these are all, again, you're putting yourself at a disadvantage by filing just the notice of lien. So we want to try to avoid those disadvantages by coming in as a party. Again, well, here's the big one here. So if you do file just a notice of lien, the plaintiff's attorney gets 2 contingency fees. He gets a contingency fee as to his client, 40%, right, of that judgment, basically now, and sometimes it's more, and gets all his costs, and then he or she, that lawyer, gets another contingency against the carrier. All right, so let's say the lien's $100,000. So then you go and say, hey, I filed a notice of lien. I want my $100,000 back, plaintiff's attorney. They say, well, that's reduced by $40,000 because that's my contingency fee. So you're already down, or 40%, I'm sorry, 40%, right? So you're already down $40,000. And with cost, you're down $50,000. So you only get 50 on 100. So you got to think about that. That's an automatic deduction. Whereas if you joined as a party, they can't do that because they don't represent you. You have your own lawyer representing, our firm, B&B, representing you. So that takes that contingency, that common fund off the table. Okay. Well, here it is. Yeah, contingency fees, 40, 50%. They're going to take that against the lien. So you want to try to avoid that by joining. And let's get to that. Yeah, again, subrogation, if it's worth pursuing, you want to join the case so that you can be active in the case and know what all the issues, know the issues, the evidence, all the discovery. You really want to get in there. So this is it. This is what I'm saying. File that complaint and intervention. And we do mostly. We file it quickly because we want to be involved in it. We want to be a party. Then we're just like the worker. We have every rights they do, just like the individual plaintiff. We can do whatever we want. We can settle around them sometimes. That happens. And the third party pays the carrier first, although that's fairly rare. But it can happen. Okay. But yeah, when to file. So you can file anytime the action is pending. So if the worker's case is ongoing in civil court, you file that complaint and intervention. You can intervene anytime prior to trial. And then again, we have all the rights that the employee has. And more importantly, you can resist all those claims of employer negligence, which inevitably will arise at a mediation or trial. You want to be there to fight. You want to be there to fight that. And there's only one way to do it. File a complaint and intervention. Okay. Now we do have, as the carrier, as the work comp carrier, we have first rights of recovery against verdicts, settlements. Well, actually, not settlements. That's a separate. But verdicts, yes. If it goes to trial, the carrier has first rights of recovery. Why? Because you already paid the money out. You already paid the worker medical, temporary disability, C&R, stipend award. They already got paid. So they're trying to get paid twice. So to avoid that, we jump in and say, no, we have first rights against that recovery. The worker can get the remainder after we get ours, but that's what you want to do. And this one is, okay, this slide, independent action. Yeah, sometimes we file just by the carrier, and then maybe the employee files later, and we have multiple cases like that. Then they just consolidate the actions. So there's no problem with doing that. Okay. And damages, recoverable damages, well, like those are the damages that I mentioned. Measure of damages is all the benefits that the carrier has paid. All those benefits are your recoverable amounts. And again, first lien rights to the carrier. Let's get to some examples of that.
Hey, Peter, real quick question for you.
Yes.
Someone had brought up that if you have a situation where the case is accepted, benefits are being provided, and there is treatment for a non-industrial condition. In this case, it was a DVT issue that required CT scans and ultrasounds. Is that something that would be recoverable even though it's not directly caused by the accident?
Yeah, you have to show that the injury is an industrial injury, and that you paid benefits due to an industrial injury. So that one, if they're well, why would a carrier be paying something that's non-industrial?
Well, no, if it requires them to receive treatment on the industrial claim, generally speaking, that is covered under the workers' comp, even though it's not directly caused by the accident.
Oh, okay. Well, yeah, there would be a situation. I mean, you're going to have to show some causation that the carrier paid money for an industrial injury. Well, they always do that, but that was aggravated in some way or required the carrier to pay additional benefits due to some other event. So yeah, you got to tie those in somehow. It can't be, it has to be causally related to the industrial injury. And that's why you paid it. So I'm not sure I answered that one, but again, the example that I was giving is the car accident following the industrial, right? You had then there's a spike in benefits right after that auto accident. You can see it in the benefit printout. The carrier paid more. Well, that's your aggravation. You get that aggravation. But in that example, I'm not sure. Again, you'd have to.
We can address that. I know we're running a little tight on time.
We're running out of time.
But
yeah, that's a good question, and some of those issues come up, and then that takes more investigation. Okay, let's see. So you're always looking for total value. So let's go and do a couple of these examples. Okay, total value in this case is, and this is civil court, guys. So we're in civil court. So total value employees at LA Superior Court, Los Angeles Superior Court, where I worked for 6 years as a research attorney, actually. So I saw a lot of these. 500,000. Okay, and the carrier paid 100,000. Okay, good. You want to then determine, well, out of that 500, can we get it all back? Looks like we probably can. Well, we can in the first example. There's zero negligence for the employer. So what the court does is they take whatever that negligence is, and that was determined through the trial, testimony, evidence. The employer was negligent. The employer wasn't negligent. The employer had nothing to do with it. In this case, the employer had nothing to do with it. Zero. So 0 times 500,000 is 0. So you get your whole 100,000 back. That's you get the whole thing back. There's no employee recovers their 400 and the carrier gets 100. Everyone goes home happy. We get our money. Okay. Now we have 10% employer negligence. Looking at that same verdict, 500,000. Now what? Okay, well, 10%. So you multiply that negligence 10% times 500,000. That's 50,000. So now you got to deduct that from your lien. You're not going to get 100,000 back. You're only going to get 50 because you can't get the way the court looks at it, the way the statute looks at it, the way the case law looks at it. The employer, the carrier cannot seek reimbursement for their own fault. So it's reduced. So then you only get 50. Okay. Let's look at the next one. This is employer 90. So that's a lot of employee 90, defendant 10, but still employer 0. So threshold amount is that amount that you get to recover is, well, in that case, it's only going to be 50,000 because you can't get 100 because the whole judgment was only 50 due to 90% employee negligence. It knocked the whole case down to 50,000. So you only get 50. So, okay. I was told there would be no math. So hopefully no more math. I don't want to do any more of those. But negligent employee, again, although it's not, we're not liable for what the carrier, we're not liable for what the employee does. But as you can see, if they're negligent, it takes the value of the whole case down. So that's just the way it is. Okay, here's another one. We're going to skip that one. We've done enough math for today. All right, credit rights. Credit rights, guys. Petition for credit. You want to get a credit for whatever the net recovery is for the worker at the board, right? He's at the board. There's a CNR pending. He wants to get all his money. He just got a bunch of money in civil court. He walks across the street and says, hey, I want to get the same amount of money from you guys. No, you guys step in. Defense attorneys step in. We file, my colleagues file a petition for credit. And that credit is, the amount is the net recovery, whatever that net recovery is, that's deducted from any CNR. So you don't get full value, you don't get paid twice. So that's what you want to do. And again, here, well, again, it'll be the same. You'll get the same negligence arguments. So you have to fight that. You'll get the same negligence arguments, but you still want to go and get as much credit as you can get. But if there's certain findings, well, now here, we can do one more math, I guess. So 20% of 500,000, that's 100,000. So that one, if your lien's 100,000, that would wipe out your credit too, because you didn't pay more than 100,000. So those issues, the same issues that arise in civil court, they are going to arise at the board too. I can help you with those and fight those, but we have some that we're working on, but yeah, that's an issue. And every AA is going to say negligence of employee, you get nothing, but we can talk about that and try to fight them on that. But as you can see by this example, potentially could wipe it out if there's enough employer negligence. Now, of course, we argue there's no employer negligence. It was the third party. That's something you just fight. And again, if it's 50% comparative negligence, that means you would have had to pay out carrier 250,000, and since you only paid out 100, you're not getting anything back probably on that one because you'd never paid $250,000. Again, 50% employer negligence, that's going to be a tough one. Okay, but you still want to use that credit. You still want to use the credit so that you can, it's a bargaining tool. Those AAs don't want to go to trial on a petition for credit. That's a civil trial. That's a full-blown civil trial. And they never do it. I did it in ADR. I had to do it in ADR, and it was a week-long trial. So, but at the board, you can use that as well. You want to file it anyway. You're going to file that petition for credit anyway, and then you negotiate the value of it. But again, it would require a trial, and work comp judges don't want to do that either. So, but you want to terminate benefits as soon as possible. You want to get that credit. So how do you get it? Well, you file the petition for credit right away. Now the AA is probably going to object to that, and then you're going to need an order from the court. You're going to need an order approving the petition for credit. You have to get that before you can stop benefits. You can't just stop it because there's a net recovery carrier. You need the order. So that's where, you have to work out a deal with AA, or, try the case as well. But the credit offsets can offset anything, can offset temporary disability, permanent disability, CNR amounts, liens. I've used it against lien holders before, saying we have a credit and we owe you nothing. You go to AA and applicant for that. So we definitely use that. Okay, can't get a credit against serious and willful or 132A type cases. Well, those aren't covered by insurance anyway, so that would not be possible. But as I just mentioned, use credits against lien claimants. Absolutely, it applies against them. That petition for credit is if it's more than the value of the work comp case. If the petition for credit is more than the value of the comp case, you owe nothing. Theoretically, you owe nothing. But again, discovery or issues could arise there, and trials could arise there. Asserting the credit, getting the court to order it. But here, perfecting it, you need the judge to give you an order of credit. But you can work that out with applicant's attorney too. Maybe you don't get the whole credit. Maybe you got $100,000 credit and you agree to $65,000 credit. It's there for your negotiation purposes, but you have to perfect it. Okay, and again, the only way to get it is have the court, just like an order approving compromise and release, you need order approving petition for credit. Must get that somehow. This is new, guys. This just came up. This isn't law yet. This is peace officers, firefighters have certain rights now. Well, this is SB 487, not a law yet in the legislature, but if it passes, signed by the governor, then 2/3 of any third-party liability policy, for example, that has to go to the firefighter or the police officer. So they technically have first lien rights in that case, but only in this limited case, and no petition for credit against a police officer or firefighter. So just something that adds protection to them. Okay, we're done. We finished, and it's 12:58, so we did good.
You did great. Thank you so much, Peter. And oh my gosh, you guys, you really did keep Scott busy the entire hour, Scott. Great job on answering all those questions for us. Thank you, Scott.
Yeah, thank you, Scott.
Yeah, I was trying to keep up on all of them, so I didn't have to keep interrupting you since I know there's so much material.
Oh, yeah, and again, guys, we went through so much in such a speedy fashion. This PowerPoint's available. We can send it to you. Tammy can send it to you, and you can spend more time with it, take a look at it, and have questions. And of course, there's my information.
Feel free to one quick question. This just came up in one of the last questions. I've never ran into this. If a third-party settlement is paid into a special needs trust, are you still entitled to credits, or would that affect anything?
I'm sorry, can you repeat that one more time?
Sure. If a third-party settlement is paid into a trust, so a special needs trust, would that have any effect on credits, or would you still be able to pursue those credit rights?
Yeah, I think, that special needs trust, that's not going to affect, I don't believe so, the first lien rights of the carrier. So that would be another step to getting your money. You'd have to figure out how to get your get reimbursement from the trust. So yes, I mean, we've had bankruptcy cases where we've gone to bankruptcy court and recovered from the bankruptcy payout. Now, this special needs trust it's not bankruptcy, but yes, those first lien rights travel. They travel around. So we took it to bankruptcy court once and recovered from that eventual distribution. So I think the same would apply here, that that you'd be able to, once the money's distributed, then you would be able to assert your lien rights against that as well. Yes. Although, yeah, I personally have not had to do that particular fact pattern. No.
Thank you. Thank you, Peter. And thank you again, Scott.
Yes.
Just a quick reminder, you guys, I will get certificates out this afternoon. You can register for our October 8th webinar with Sherry Dozier on audits now. Also, our November webinar is up with John Kamen. Believe it or not, this is going to be his, I know he's on here. Hi, John. It's going to be his 10th year doing the legislative update for us in November. So we're going to have that coming up in November as well. You can register for that now. And we always appreciate you joining. We appreciate you asking questions and making it interactive. And I hope you all have a great rest of your week. Thank you.
Yes, thank you, guys.
Thanks, everyone.